Permanent alimony. Permanent alimony. Let that sink in for a moment. Florida law has changed since 2023. If your case was already underway but not finalized, or if you have a new case, permanent alimony in the vast majority of cases does not apply. It is not a thing. It is not going to happen. However, if you had a divorce settlement or a divorce judgment that finalized before the law change in 2023, you may be on the hook for paying permanent alimony. Can permanent alimony be undone? There's some arguments as to retirement in the new statute, or the new version of the alimony statute, I should say, allows folks to begin preparing for their retirement and potentially changing alimony, and it gives them a grace period to start their lawsuit. This is both smart and equitable. It is smart because it allows the payor, the person paying alimony, to begin preparing and finding out if they really can retire. Unless, of course, retirement is a necessity, in which case, if you have no choice due to age, physical disability, some other infirmity, or perhaps your job no longer exists and that change is permanent through no fault of your own, in other words, it's involuntary, there may be certain arguments there. However, there's something that a lot of people missed. The fight used to be pre-2023, the summer thereof, the fight used to be over the language in the marital settlement agreement. Permanent alimony, non-modifiable, permanent, periodic alimony. The fight was on over the language. And the language of a marital settlement agreement is your contract. It controls over Florida statutory law. Many Florida district courts of appeal have ruled as follows: that the statute does not triumph or trump the language used in your marital settlement agreement. In other words, if in your marital settlement agreement you had blanket language that said unequivocally permanent, non-modifiable periodic alimony to be paid monthly from former husband to former wife or former wife to former husband, that language existed with no caveats, no exceptions, no alternatives, then the Florida District Courts of Appeal will generally say alimony is permanent at the amount specified, come hell or high water, come what may. However, many people, in order to enter into a marital settlement agreement and stop their case without additional litigation, allowed for some hedging language. Hedging language such as, wife will pay to husband permanent periodic alimony that is non-modifiable unless husband remarries, husband dies, wife dies, husband enters into a supportive relationship, husband's income increases to the following level, in order to prevent any kind of fraud in the case, such as maybe the husband could have been earning $200,000, but magically stopped working right before the case in order to obtain alimony. There are so many facts of each and every individual case, it is hard to really predict these things. This is why there would be that language. And you think, as the person that is receiving alimony, it's non-modifiable, it's permanent, I have it forever. But if the language says if you get involved with somebody romantically and then you rely on them for financial support, that your alimony award could be reduced, it could be terminated. Now, that may be statutory too, but the marital settlement agreement typically controls. The language that you agreed to specifically and uniquely in your case will control. You entered into a contract. That contract dissolved a business partnership. Nobody likes to think about marriage as a business, but it is treated as a business in the event of a divorce. 50-50 presumption applies unless rebutted and unequal distribution is appropriate. Different topic, different day. Back to alimony. Permanent periodic alimony is not necessarily permanent, and non-modifiable alimony is not necessarily non-modifiable. The facts of your case, the language of your agreements, And what you agree to at the time of your divorce settlement pre-2023 is what is going to control and determine the fate of that alimony award. Well, what about the fact that there were tax implications before that may have changed through tax law changes? That does not change the allotment or amount of alimony. Permanent and non-modifiable is not necessarily permanent. It is not necessarily non-modifiable. Every case is different, and the big retirement may intervene. The absolute impossibility of paying may intervene. Think of a scenario in which somebody is ordered to pay permanent alimony. However, their income has been drastically reduced, the economy has changed, the landscape of the world has changed, salaries have changed. Even if the other party, imagine in your language, if it says permanent, periodic alimony, non modifiable with no exceptions, with no pathway to reducing it or terminating it, and the other party who's receiving alimony gets married and has a better job now than they did then, you still might be on the hook for paying alimony forever. Conversely, if that language gave you an out or some leeway for a reduction in the amount that you have to pay, even if it is contrary to Florida statutory law, a district court of appeal, I'm assuming that this will not end at the trial court level, but a fight it may be and the amount of money involved, a district court of appeal is likely to look first to your marital settlement agreement rather than to Florida statutory law in the backdrop. Nothing that I've stated here today is legal advice on the Divorce and Family Law podcast. My goal is to educate you folks about Florida family and divorce law and to give you some information to consider, to think about, as this may apply to your life, to a friend's situation, and you may just simply want to learn more about the law, which is a noble goal, which is why so many of us went to law school in the first place. Thanks, everyone.